Here to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what is called an arraignment. Arraignment basically is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have here in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your more serious type of criminal offenses, whereas your misdemeanor cases are commonly referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. When I use the word serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felonies are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, or the state jail felony. The capital murder is the highest felony that you can get. Now, if a person is convicted of a state jail felony, which is the lowest felony, the range of punishment, if convicted, is a minimum of 6 months to a maximum of 2 years in the state jail, a fine from $0 to $10,000. If you're convicted of a third-degree felony, range of punishment is minimum 2 years in the state penitentiary, a fine from $0 to $10,000. If you're convicted of a second-degree felony, range of punishment is minimum 2 years to a maximum of 20 years and a fine up to $10,000. If you're convicted of a first-degree felony, range of punishment minimum is 5 years to a maximum of 99 years to life in the state penitentiary and a fine up to $10,000. Now, if you're convicted of a capital murder, which is the highest felony, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. You don't have to worry about that. This case that you have here is not a felony case. It's a misdemeanor. Misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down. It starts off at you have a Class A misdemeanor, Class B misdemeanor, and then a Class C misdemeanor. Your Class C misdemeanors are cases that are they originate in the city court or the JP court. And if a person gets convicted of a Class C misdemeanor, the range of punishment is fine only. Usually the fine is anywhere from $0 to $500. You cannot be given jail time. However, if you fail to pay the fine, or if your fine was converted to community service and you failed to perform the community service, the court can issue what is called a capias pro fine, which means it's a warrant for the fine. You could be arrested to sit out the fine in jail. Now, if you're convicted of a Class B misdemeanor, and normally we handle Class A and Class B misdemeanors, we handle Class C misdemeanors when they are appealed from the JP court or the city court. So if you're convicted of a Class B misdemeanor, range of punishment minimum 0 days to a maximum of 180 days in the county jail, or a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, range of punishment 0 days, minimum to a maximum of 365 days, which is a year in the county jail, or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, if you are eligible for probation, there are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation basically means that you would not have a conviction on your record because you would not be adjudicated for the offense. And so with unadjudicated probation, if you successfully complete that probation, you won't have a conviction on your record, and you may qualify for what is called a non-disclosure. A non-disclosure basically means that we cannot disclose the fact that you were on deferred adjudication to the general public. In essence, your record is sealed to the general public. However, The government can have access to it. Now, the other type of probation is called adjudicated probation. You have unadjudicated probation, and now you have adjudicated probation. With adjudicated probation, that simply means that you will have a conviction on your record. However, there's something that is called judicial clemency, where the court, the judge, can set aside your conviction. And in order to qualify for that, you have to first complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged or let off the probation. If those three things happen, then the court can set aside your conviction. And that just simply means that you will not have a conviction because it'll be set aside. Now, however, if you get a subsequent conviction, in essence, if you get a conviction later on for something else, then this case that you receive a judicial clemency on can be resurrected, brought up, revived, resurrected, and used against you. If you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, the other thing that I want to talk about is the rights that you have. You have, first of all, you have a right to have an attorney. On the clipboard that has been handed out, the first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And it states, as a defendant in a criminal case, you have three options. The three options are regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Number three, you may represent yourself. Now, you can do that by waiving your right to an attorney or giving up your right to have an attorney. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date from today to give you time to hire your attorney. If you want an attorney and you do not have enough money to hire an attorney, you would need to fill out a financial questionnaire. Now, that financial questionnaire is the third document on that clipboard that is titled Affidavit of Indigence, Jefferson County Affidavit of Indigence. Now, you would have to fill out that document so that the proper person can determine whether or not to appoint an attorney to represent you. Now, on that document, basically, you'll fill out the first page and half of the second page. And then the remaining, the second half and the third page will be filled out by the judge or by the court. Now, if you want to speak to the prosecutor, we have some prosecutors sitting at the table before you. They work for the Jefferson County District Attorney's Office. They are assistant district attorneys. If you waive your right to an attorney and represent yourself, that simply means that you will not have no attorney representing you. You'll be representing yourself. Then you will be allowed to talk to the prosecutors. Now, you cannot speak to the prosecutors unless you first sign a written waiver of your right to be represented by an attorney. The written waiver is the second page on that document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Once you sign that, read and sign that document, then you'll be allowed, you'll be waiving or giving up your right to have an attorney, and you'll be representing yourself. In essence, the legal term that we normally use is pro se. You'll be pro se, meaning that you'll be representing yourself. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, that is, if you decided to represent yourself, you may change your mind at any time, and you may request that the court appoint you an attorney to represent you. Now, at the bottom of that first document that is titled Judge's Explanation of Rights to Defendants Without an Attorney, at the bottom of that document, in bold letters or bold print, it says defendant's choice. Mark initials next to only one choice. Now, if your choice is to hire your own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to have an attorney or give up your right to have an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant. And you will date it today's date, December 12th, 2023. Now, for those of you who will be waiving your right to counsel or waiving your right to an attorney and representing yourself, as I mentioned earlier, you would have to read and sign the second page on the clipboard, which is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, which means no one is forcing you to do it. You're doing it of your own free will. And intelligently, intelligent means that you know what you are doing. So you're saying that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 12th day of December of 2023 by the County Court at Law number 2 of my right to counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive, which means I give up my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date on the line that is titled date. Now, ladies and gentlemen, you not only have a right to have an attorney to represent you, but you also have a right to have a trial by jury. What a young lady is sitting over there, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all the evidence that is presented in your case. They will also listen to the arguments of the lawyers, and they will deliberate, and then they will decide to find you not guilty or guilty of your charges. You also have a right to waive your right to have a jury trial. Waiving means you have a right to give up your right to have a jury trial. If you waive or give up your right to have a jury trial, then your case will come before the court or before the judge in one of 3 ways. One way it will come before the judge is by way of a trial. That trial is called a bench trial. It simply means that it's a trial by judge only. You don't have a jury. And the judge will listen to the evidence and the arguments, and then the judge will decide whether or not to find you not guilty or guilty. The other way that your case will come before the judge is by way of an unagreed plea bargain agreement. Now, what a plea bargain agreement is, it's an agreement that you work out with the district attorney's office to settle your case. Now, if you're unable to work out a plea bargain agreement, we call that an unagreed plea bargain agreement. If you have an unagreed plea bargain agreement, it becomes before the judge, and the judge will set the punishment in your case. The other type of plea bargain agreement is an agreed plea bargain agreement. That simply means that you and the state have reached an agreement to settle your case. It will come before the judge, and the judge can do one of two things. The judge could accept or reject the plea bargain agreement. Now, if the judge rejects your plea bargain agreement that you made with the state, you can take your plea plea back. In essence, for example, let's say the state says, well, judge, we come to an agreement, and that agreement is for the defendant to be placed on probation. And the judge says, well, I'm not going to follow that plea bargain agreement. Well, you say, well, judge, since you're not following the plea bargain agreement, I take my plea back. You can do that. In essence, you say you're withdrawing or taking back your plea. Now, if the judge does follow the plea bargain agreement, then in 30 days, within 30 days, you say, you know what? I think I've been wrongfully convicted. I want to appeal my case. Then you have to get permission from the judge that followed the plea bargain agreement if you want to appeal your case. And what I mean when I say appeal, you'll be asking a higher court to review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. That higher court that your case will be appealed to, ironically, is located right above us on the 3rd floor. It is called the Ninth Court of Appeals. They will review your case to see whether or not you've been wrongfully convicted or whether or not an error was committed by convicting you. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means you'll be representing yourself. You will not have a lawyer representing you when you file the petition. And you'll be asking the Texas Court of Criminal Appeals to see whether or not your appeal should have been granted, whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. They could either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals, or they can send the case back to this court with orders to give you a new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court to testify. They can testify either for you or against you. You can ask the witness questions if you're representing yourself, or if you have a lawyer, your lawyer can ask them questions. We call that cross-examination or direct examination. You also have a right, a Fifth Amendment right, against self-incrimination. That simply means you have a right not to testify in your case. The state can't force you to testify if you exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your right of your Fifth Amendment right against self-incrimination. And by waiving or giving up your right against self-incrimination, that basically says that you will be testifying in your case. You also have a right to have discovery. Discovery just basically means you have a right to see the evidence that the state will be using against you, or discover what that evidence is that the state will be using against you. For example, the state may have documents, witness statements, your statement. It may have lab reports, police reports. It may have other documents or audio recordings, video recordings. It may have instruments or whatever evidence that they have that they'll be using against you. You have a right to have access to that evidence. Now, you can waive, which means you can give up your right to have discovery or give up your right to have access to the evidence that they will be using against you. Now, everyone that's here today for arraignment, you're here because you are out on bond. You were arrested, you were released on bond, you was either released on a cash bond, which means you paid the full amount of the bond to get out, or you was released on a surety bond, which means that you paid a percentage of the bond to a bondsman to get out of jail, or you were released on a PR bond or a personal recognizance bond, which means that you did not pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, whether or not it was 1 day, 1 minute, okay, will be 1 day, you can get credit toward your fine, well, toward your punishment. So, for example, let's say you spend 5 days in jail, and you and the state has worked out a plea bargain agreement for you to serve 5 days in jail. You would not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that means you would have to do 2 days in jail. Okay? Every day that you spent in jail will also go toward your fine and court cost at $100 per day. So if you spend 5 days in jail, that's $500 that can go toward your fine and court costs. So if you and the state have worked out a plea bargain agreement for you to pay fine and court costs of $500, you won't have to pay $500. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if they are offering fine and court costs of $700, you spent 5 days in jail, which is $500. That means you have to pay $200. Now, you'll be required to pay $200 on the day of the plea. If you're unable to pay the $200 on the day of the plea, then the court can allow you to pay off the remaining balance in installments, in monthly installments. And once it's paid off, you will no longer have a balance. Now, if you cannot pay off the balance in monthly installments, then the court can convert your fine and court costs to community service. And the way it works is as follows. Every 1 hour of community service that you perform at a nonprofit organization in our community, $12.50 will go toward payment of your fine and court costs. So, for example, if you work 8 hours 1 day at a nonprofit organization, $100 will go toward your fine and court costs. Okay, because it's $12.50 for every hour that you work at a nonprofit organization. Now, if you have never been in trouble before, if your first time getting in trouble, and well, Jefferson County has a program where they will dismiss your case and you can get it wiped off your record. The program is called pretrial diversion. Now, in order to qualify for pretrial diversion, you have to have an attorney to assist you with the application. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest, and it has to be your first time getting into trouble. And as I said earlier, first time getting in trouble, they can, and if you, they'll dismiss the case if you get into the program, and if you successfully complete the program, you can get it expunged, which means wiped off, erased, or deleted from your criminal record, like it never happened. Jefferson County also has a program that is called Veterans Court. We have someone here with the Veterans Court program. They're going to come to you in a little bit and tell you a little bit about that program. But basically, with the Veterans Court program, what they will do, they will, if you get into the program, and that this program is for veterans only. If you are served in any one of the branches of the United States military, you can qualify for Veterans Court. And with the Veterans Court, you get into the program, you complete the program, they dismiss the case, and you can get what is called a non-disclosure, like I mentioned earlier with the non-disclosure, whereas your record is basically sealed from the general public. Okay. Now, in order to qualify, you have to have served in any one of the branches of the United States military. And the Veterans Program also have other resources that veterans can take advantage of. And as I mentioned earlier, she'll come forward and tell you more about the Veterans Program. Now, this court also has a program that is called pretrial. Well, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within 100 days of taking office. And I started that program in March of 2017. So the program has been going on for 6 years, going on 7 years. With that program, the program is designed to address the issue of what we call recidivism. Recidivism is just a word that means people commit crimes over and over. So how do we address recidivism? Well, we address recidivism through the Community Safety Initiative. And with the Community Safety Initiative, we have partnerships with local agencies. One of the partnerships that we have is with Spindletop Center. Spindletop is our local mental health authority in the Southeast Texas region. Now, in order to qualify for the program, you do not have to be insane or incompetent. You could just merely suffer from anxiety, depression, or any other host of mental illness. With that program, what Spindletop will do, basically, they can have what we have called is a private interview with you. It could be here in the jury room, or it could be at their facility, or they may be able to do it by phone, whichever is convenient for you. Then they can do an assessment and develop a treatment plan, either outpatient or inpatient treatment. Now, they also have a program at Spindletop that is called ATAR, and our local Drug and Alcohol Council has a program that is called OZAR. Now, ATAR stands for Addiction Treatment and Recovery. OZAR stands for Outreach, Screening, Assessment, and Referral. Both of those programs are alcohol and drug recovery programs. So if you have issues with drugs or alcohol, well, with those programs, they'll be able to do an assessment. Well, first of all, they'll have a screening, an assessment, and then they can develop a treatment plan, either outpatient or inpatient treatment. And you could refer to facilities to address your alcohol and drug addiction issues. If you are unemployed, do not have a job, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. If you have not graduated from high school and you would like to get your GED, your graduate equivalency diploma, well, CICE has a GED program. Now, one of the benefits of all of these programs that I just spoke about is the fact that all of these programs are free. And that simply means that it does not cost you anything but time. And I like to say here in this court, we do not just give time, we take our time. That simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, we believe that productive people would not commit crimes. Why? Because they have too much to lose. And so I say this all the time. When you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we believe that if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community. Why? Because what comes out of the community what comes out of the home goes into the community. And so that's why we say that in this court, we do not have court as usual. We have unusual court. Now, one of the other benefits of the program is the fact that all of these programs that I just spoke of can be used as community service. So, for example, you were ordered to pay a fine, you can't pay the fine, so we converted the fine to community service, right? Let's say you are getting mental health treatment, or maybe you're getting drug treatment or alcohol treatment, or you're in a job training program, or you're working on your GED. 1 hour in any one of those classes will go toward the program, will go toward the community service, and then $12.50 will be paying off your fine and court costs. So you're killing 3 birds with 1 stone. In essence, you're in a program, you're doing community service, and you're paying your fine and court costs. And as I mentioned earlier, all of these programs are free. It does not cost you anything. Only thing you have to do is have a desire to be in the program. Now, as I mentioned earlier, we have folks from Spindletop that's going to come before us today and tell us a little bit about the program that they have. And we also have someone from the Veterans Program that is also going to come and tell you something about their Veterans Program. So at this time, they can come forward.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission with the sheriff's department. I'm here with my coworker, Jackie, and also Lauren. Jackie is a qualified mental health professional, and Lauren is a veteran affairs specialist. The reason we are all 3 here this morning is because the judge cares about every single person that comes before him. The judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources.
Well, when it means mental health, anything basically, it can be anxiety that almost everyone experiences sometimes, and it doesn't help being in the court system. The pressure of being in the court, but also with your life situations, your life doesn't stop once you come here, and we can understand that. And so we try our best to see what we can do to help y'all, even if it's just support, but also connecting with our services or any services in the community also. And so it goes farther than just disabled mental health. It's just any pressure you have right now. And it can be depression, anxiety, anything like that we all sometimes go through. We have periods that we go through.
So maybe this is your first time to be here, maybe it is your 10th time to be here, you feel hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. And you should share that need with us. And Debbie's gonna explain how you can do that very privately.
So this form is not only for people who are showing up today in court, it's also for family members and anybody that you know also. It's not just for people who are coming up here, but for everybody. We want to try and help everybody that we can, the best we can. With this form up here, different things that are really important are, we have check boxes here, we made it general for you, then, just general, like the medical employment, how you can check on those boxes for us. Also, we left a space right here for other. If you have any specific need, please put it down right here. Also, if you'd like to speak with me privately today, you can smart answer them right here. And also another thing that's really important is I need a good phone number from you. The one thing that I will do is, I'll be texting you, and this information is not shared by anybody else except me. You're not gonna get an automated call or any random text messages. You'll receive one text message from me, and it'll just be introducing myself and just seeing what resources you need. If you don't want to respond, you don't have to, but it'll just have my work phone number, so if you have any questions, you can also get back to me there also. But, it'll be one text message that you're choosing. I won't blow up your phone if you choose not to respond, but if you do respond, I will work with you as best I can with you and with your family.
Good morning, my name is Lori, and I'm with the Military Veteran Care Network Program under Spindletop. Do I have any veterans in here today? A veteran is anyone who served one day in any of the armed services. Is anyone in here married to a veteran? The widowed or widower of a veteran? Or have anyone who's a veteran in their household? Okay, I'll keep going for me. So what we can do is we go out and we search for veterans. We can help them with peer support, where a veteran speaks to a veteran. We understand each other's language when it's a veteran with a veteran. We can help them with mental health counseling, possibly some financial assistance, depending upon what is needed for that family member. Give this to you. You can fill this out. Oh, identify, you can put yourself there and then identify who the veteran in your household is. You can have to access benefits, whether it be medical or disability benefits. We can also help them access other resources.
I also have this flyer that I want to get in everyone's hands. On the back of it tells you really about the advantages of participating. It also has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number if you help you need it. Now, just shortly, the judge is going to go into recess, and when he does, we'll be able to come out there, we'll visit with you, I'll get this flyer to you, we'll pick up those forms from you as well. And we'll be able to communicate, talk, visit, whatever is on your mind, we'll be able to entertain at that point in time. Thank you, Ron.
Okay, thank you, Deputy Hinton, Gabby, and Lori. Okay, ladies and gentlemen, the paperwork that you have on the clipboard. If you need any help filling that paperwork out, we have our court personnel who's here to assist you with filling the paperwork out. Now, once the paperwork is filled out by everyone, then we're going to take the paperwork up. We're going to put you in various different categories, and then we're going to call you to come before the bench one at a time. Now, that's going to take us a little time to do. In the meantime, if you need to use the restroom, there are 2 restrooms right outside of this courtroom in the hallway. The men's restroom is right in front of County Court at Law Number 3, which is next door. The female restroom or the women's restroom is on the other side of the hall in front of the 172nd District Court. Now, if you use the restroom, leave out of the courtroom, make sure you do not leave the courthouse, because if you leave the courthouse and your name is called and you do not answer, then a warrant can be issued for your arrest. and you'll be arrested and placed in the Jefferson County Jail. Okay? So at this time, we're going to go into recess. Make sure that you do not make a lot of noise, just remain quiet. We're gonna have someone from our court to assist some of you who might need help. Now, just by show of hands, how many people will need help filling out the paperwork? No, what? Okay, well, one person, okay. All right, now, our court personnel is gonna come and check the paperwork. They may ask you to make sure that, let me tell you this now, if you're filling out the affidavit, Jefferson County affidavit of injuries, make sure that everything is filled out. For example, if you are filling out where it asks you for your monthly income. Now, and on that, if they ask you if you have governmental benefits, don't just leave it blank, just put 0. Okay? And where your monthly income is, you're gonna place your monthly income over the top. Okay? All right. So at this time, the court is going to go into recess. And